afternoon, everyone. Thank you for taking the time to join us for this webinar on the true cost of going to trial. My name is Kate Silburn, and I own Rocky Mountain Elder Law. I practice out of Lakewood, Colorado, but I practice up and down the Front Range. I also have clients on the Western Slope. I grew up in Crested Butte and have many clients in the Gunnison Valley, and I don't limit my practice to just the metro area. I am someone who's been practicing for 27 years, primarily in the area of trusts and estates, guardianships, conservatorships, will contests, trust contests, probate administration, and I do a fair amount of financial exploitation of at-risk adults, meaning adults who have disabilities or are 70 and over. I am someone who cares deeply about the work that I do and really want to convey that although this webinar may have a feel of discouraging people from going to trial, that's not my point at all. My point here is to understand the costs of going to trial and to give a kind of advance notice to persons who are interested of what it kind of looks like and feels like to go to litigation in the area of elder law or estates and trusts. I often call elder law, family law, just the other direction. It's generally people fighting over their parents rather than parents fighting over children, but in a more developed and nuanced sense with trusts and estates, it's also fighting over what I like to call is the treasure and disputes concerning what a decedent leaves behind or how that treasure has been administrated by a fiduciary. So when might I go to trial? Well, there's several areas that I cover in an elder law practice or a trust and estates practice. The most obvious is a will dispute or will contest. And that's wherein a will is set aside or challenged for any number of reasons. And then there's general probate litigation, and that's when generally a personal representative, used to be called executor, personal representative of a will is administering, and people are challenging that administration or the distribution of assets, how things are going. It can also be challenging a trustee's actions or inaction with regard to a trust. It can also be a challenge or a dispute on a guardianship. A guardianship is when a court appoints someone to look after the health care and well-being of someone, or it can be a challenge to a conservatorship. A conservator is someone who's court appointed who looks after the finances of an incapacitated person. There can be, as I touched on, arguments over trusts, primarily their administration or distributions under a trust. And then there are the cases of financial exploitation or elder abuse. Those can range from anything from scams to outright theft of an elder's property, or they can involve scams by people against the elderly. I work in tandem at times with the district attorney's office. They handle often the abuse and neglect piece, and I handle the financial, trying to go after someone civilly for monetary damages. So as an example, let's take one family's experience, and this is not directly related to a client, a prior client, or a current client. This is just a hypothetical situation. Two siblings discover they've been disinherited after their father's sudden death. The father's will was changed drastically, and they suspect undue influence. The family hires an attorney, but what happens next? The first step is, of course, understanding the financial, emotional, and time commitments involved in going after the person who had the will changed, or sometimes it's not even a family member, it's a caregiver who kind of moved in on the decedent prior to their death or during a last illness, took them to the lawyer, disinherited the family to their benefit. Sometimes the person has cognitive decline or has different challenges, but understanding the facts and the basis for challenging a will are very important. It's not just, I don't like what's going on, it's, or that I've been disinherited. There has to be more. There has to be more to the story. But it's important to analyze the facts and get a good grounding on what happened, what is known so far, what can be found out with discovery, which is part of the trial experience. But really having an attorney who sits down and helps you lay out everything as you know it. So what are the costs of going to trial? It's the title of this webinar. There's several layers of costs. Obviously, there's a tremendous emotional cost when going up against family members, which is often the case in will and trust contests and guardianships and conservatorships for that matter. There is, of course, the emotional toll that this takes. I never enter into a litigation lightly without really talking about what this may mean, not just in the past, in the current sense, but also for the future of a family. And then, of course, there's the financial burden. Litigation is incredibly time-consuming and expensive. The time is directly related to the cost. Litigations don't happen quickly. The trial courts are overburdened with cases, so often trials for any length of time are set out months, sometimes even years ahead of time. There is not just the initial pleadings that are filed, but there is discovery, depositions, motion practice. There are many layers to going to trial that are very costly. And then, of course, there's time considerations. And I talked about the burden on the trial courts, but this can strain family dynamics and finances even more. So what is the financial reality of going to trial? Costs of filing motions, document review, and attorney's fees can be enormous. Each party, respectively, can spend anywhere from $50,000 to $100,000 or more. When it's more, it often involves expert witnesses, analysis of capacity, geriatric experts. It's really dependent upon the facts of the case as to how much is going to go into trial preparation. The actual trial, the show, as I call it, is the very sort of not end point of a litigation. because there is post-trial work as well. And this brings me to the very important point of settlement versus trial. It's important to look at the overarching cost of going to trial, and then the important point of bringing a matter to a close by a settlement or mediation. Most courts will order mediation, and I'm a big fan of trying to mediate disputes rather than get into the enormous cost and length of time it takes to ultimately culminate in a trial. In my experience, over many years, it seems that settlement, a negotiated settlement or mediation can be an artful solution to what are often really protracted and difficult family disputes. It's not the same as a trial in terms of everyone getting to be heard. A lot of people think the trial is the place they can tell the story of difficult family relationships, those kinds of things. But often a trial is very limited in what evidence is presented. It's not a time to hash out the history of a relationship necessarily. Some of that can be relevant, but mediation can be a way in which no one in my experience leaves settlement happy, but rarely does anyone leave a trial happy. There's never a way in which people are completely satisfied with the result, partly because of the cost of trial. But with mediation, at least the enormous financial burden of trial is ameliorated by what is relatively a small cost of mediation. And there are excellent mediators in Colorado who deal specifically with probate disputes. And this can be a very, very good way to really manage the expectations of people and come to some kind of mediated agreement where everyone can go on with their lives without the protracted need for litigation. So the time investment of trial is something to be really aware of. Pre-trial, gathering evidence, deposing witnesses, filing motions, all of this can take months, sometimes years, just to get to trial. But all of those things are really important steps in preparing for and ultimately prevailing at trial. I am always concerned when clients or family members, resist doing depositions of the opposing party. For me, I absolutely need to do depositions in advance of trial. I never want to meet a witness on the witness stand at trial for the first time. That is always a bad idea. So the costs of pre-trial evidence gathering can be very, very high. During trial, courtroom time, I don't think it can stretch from weeks to months. There may be some status conferences and things that can lead up to trial, but usually trials are a day or a number of days. It's unusual in probate to have anything go more than 4 or 5 days. It has to be a very complex estate for that kind of length of trial. But even after a verdict, you have to take into consideration post-trial time spent There may be additional appeals, additional legal challenges, and then you have to enforce any judgment that you ultimately get. Whether it's, getting a cash settlement or garnishing or liening accounts, and homes, that kind of thing. So there's post-trial work, involved. The last day of trial is not the end, is what my point is. And then there is, of course, the very high emotional toll of going to trial. This area of law, as I pointed out, is a type of family law. And trial can cause irreparable damage to family relationships, and they may have already been irreparably damaged. But especially when siblings or close relatives are involved, the stakes can be enormously high. There's often currents of deep resentment about the care of the decedent or the care of a vulnerable adult. And this can cause enormous stress and anxiety. There's the uncertainty of trial can be overwhelming, especially when it's unclear who will prevail. In my experience, going to trial is never a slam dunk. People litigate to the point of trial because the facts weigh on both sides. The evidence is not clear cut. That's generally when settlement happens. But there can be long-term consequences to choosing to litigate. Obviously, even after the trial, the emotional scars can remain, affecting future dynamics and relationships. And I always try to be aware of that and keep that, if not at the front burner, at the back burner, so that my clients know that this doesn't necessarily end with a verdict or a judgment. So when is trial worth it? It's worth it when there's a strong case backed by clear evidence of undue influence or fraud, or when a fiduciary, like a trustee or a personal representative or a power of attorney or a conservator, has clearly misappropriated assets or mismanaged assets or favored themselves over other beneficiaries. If upholding your loved one's wishes is more important than financial considerations, and that's a big if, then going to trial is worth it. There can be a real sense of justice being done for an elderly person, for an estate, or for a trust, for the beneficiaries of a trust. However, the caveat is it's important to explore mediation and settlement before deciding to go to trial. Because again, that will be court ordered. Courts generally say the parties will mediate by a certain date in advance of trial. And again, I'm a big proponent of mediated settlements because they can often help families not only reach an agreement financially and so forth, but also deliver, hopefully, eventually, a measure of peace. So let's talk about the mediation option. This is when it's a non-judicial approach. Many mediators who deal with probate in Colorado are retired or senior judges. They're very seasoned in these types of disputes. They're extremely well versed in what the stakes are, what the damages might be, who's on the hook for what. and can be an extremely important neutral voice in what are intractable positions amongst the parties. So they basically hear everyone out and help guide what the terms of a, if you will, a truce would look like. This is obviously a less costly, a faster resolution, and often can be more amicable outcomes. And I'm not saying that everyone gets along afterwards. I'm saying that amicable in the sense that people don't have to go forward with the stress and expense of going to trial. It's, again, with mediation, here we called it an option, but it's generally mandated by the court. And so it's something that isn't just an option, it's something that courts will impose upon the parties in an effort to work things out before having to hear the case at trial. So how can we help you? As lawyers, we can help you analyze the facts and figure out if you have a good case. We can help prepare initial documents like a demand before a complaint is filed. We can help with getting to mediation even before a complaint is filed. If you're facing the possibility of going to trial, our legal team provides clear guidance on whether it's the right choice and whether you have the right facts and the law to back you up to move forward. Obviously, with mediation and settlement, we help families explore alternatives to litigation and find peaceful solutions that respect everyone's wishes. That's what we really hope for. When it does go to trial, we come alongside families or parties who feel they have been wronged or a mistake has been made or that someone has, again, misappropriated assets improperly, unduly influenced an elderly person or someone who's in their last illness. And then we fight for what's rightfully theirs. And I take these fights very, very seriously. And I have no qualms about going to trial. But the purpose of this webinar is to talk about the true costs of what that decision means. So what can you do now? I recommend that if you suspect fraud or undue influence or financial exploitation or misappropriation of funds or mismanagement of assets in a trust or via a will, that you consult with an attorney. Get an honest assessment of your case and explore alternatives like mediation. Now, it's very important that you don't feed all the names and the facts into ChatGPT. I'm just going to do a little aside here. Right now, under the law, in the Southern District of New York, a decision was recently handed down that all ChatGPT searches were discoverable in a case. So all legal information and things that ChatGPT was asked about, all the questions which are most important that you would normally ask a lawyer, are discoverable. They're not protected by attorney-client privilege. So as you're exploring the merits of your case, please listen to this note of caution about feeding everything into AI. I think that is a huge mistake because all that can be turned over to the other side if something went to litigation and discovery happened. So understanding the costs, it's important to be aware of the financial, emotional, and time commitments involved in litigation. It is a decision to be weighed carefully and thoughtfully, and hopefully with the input of an attorney who is relatively seasoned in this area of law. It's a complex area of law, not just the law surrounding will contests and trust contests, but particularly the behavior of fiduciaries. And that means personal representatives under a will, powers of attorney, agents under a powers of attorney, trustees under a trust, guardians, conservators, all those fiduciaries have specific kinds of legal obligations and duties towards whether it's the beneficiaries of a trust, the beneficiaries of a will, a protected person under a conservatorship, or what's called a ward under a guardianship. So these are not simple kinds of analyses to make. It's important to consult with an expert to understand precisely the scope of these duties and what kinds of legal ramification for breaching, that's what it's called, breaching those fiduciary duties are. It's important with your attorney to set clear goals and know what you hope to achieve and determine if trial is the best route, or if there are preliminary actions that can be taken to resolve a dispute without the enormous costs of trial. So we have prepared what's called a consultation prep checklist. And this contains the key information to gather and questions to consider before you talk to a lawyer about going to trial. I recommend that you go over this list and really think through what it is that might be your legal problem or your desire to legally challenge a will or challenge a trust or challenge the conduct of a fiduciary, and to get kind of a sense of the lay of the land so that you can bring that to an attorney for the initial consultation. But this is some of the information that you will be asked to gather. So it's important to kind of get it preliminarily laid out so that the attorney can adequately analyze and determine what's going on in terms of the facts.